On the public law grounds, Hal invites the court to uphold the reasoning of the Divisional Court and gratefully adopt the submissions made by my friend Mr. Palmer. As your Lordship knows, the Secretary of State and Hal have filed respondents' notices which invite the court also to uphold the Divisional Court's conclusion on the Article 106 challenge, but for reasons additional to or different from those given by the court below. In outline, there are 5 headings which I intend to cover in my submissions. First, I'd like to deal briefly with the Divisional Court's findings of fact as to what Hal actually did and the position it took in relation to the claimant's proposals. Secondly, I'll deal with the Divisional Court's reasoning from paragraph 156 onwards and make some brief submissions on why the court ought, as a matter of principle, not to have gone down the path of making lengthy observations on points of EU competition law that did not, on the court's own analysis, arise for determination in order to dispose of the claim. Third, as to the substance of those points, I'll deal first of all with the finding that Hal is an undertaking that has been granted special exclusive rights under Article 106, and I'll be able largely to build on the submissions you've already had from Mr. Palmer on that point. Similarly, my fourth heading relates to the alleged risk of abuse of a dominant position and market definition, and again building on Mr. Palmer's submissions, I'll deal briefly with why we say the Divisional Court's approach to that was wrong. And then fifth and finally, I'll seek to make good the submissions at the very end of my skeleton, paragraphs 27 to 32, that there was no basis for even a hypothetical finding of abuse of conduct by Hal, in particular because Hal's position in respect of the request by Hal for a guarantee or assurance was objectively justified. In other words, even assuming there were circumstances that might amount to a prima facie abuse, there was in fact no breach of EU law by the Secretary of State because Hal's reservations about the ENR proposals were legitimate ones that it was quite entitled to raise. So coming first to my first heading, which are the factual findings, it is in my submission important to recall throughout these arguments that Hub was not the proposed developer for its own scheme. Hub wanted a third party, namely Heathrow Airport Limited, to be the developer. Indeed, Hub's whole raison d'etre was to try to achieve policy support for its ENR scheme in order to sell the intellectual property rights to Heathrow Airport Limited. Now, Hull's submissions to the Divisional Court on the facts and the court's findings in relation to those submissions are recorded in the judgment in paragraphs 34 to 37. Could I ask you, Mother, just to read that part of the judgment for a moment?
Yes.
So, at just picking it up at 33, by the time of the conclusion of the safety principle between the claimants and the Secretary of State had understood the claimant's position, although the claimants had no intention of delivering the ENR scheme, Hull and the owner-operator of the airport could implement the scheme that was proposing its own scheme, which it preferred. The claimants appear to have been of the view that Hull had taken that position primarily as a result of the conflict of interest that Hull had because it was promoting its own NWR scheme, rather than as the result of the respective merits of the schemes. But in his submissions on behalf of Hull, Mr. Humphrey stressed that Hull's preference for the scheme was not based on purely commercial self-interest. To the contrary, Hull, as an experienced operator of Heathrow, raised a series of technical and planning concerns about the ENR scheme, which it made in its response to the Airport Commission's initial assessment and with which it persisted. These concerns are described in evidence, notably in Holland-Cave, paragraph 14. Just pausing there, unless you've already done it, the bundle reference to Holland-Cave's witness statement is supplementary bundle 3, tab 61, and the paragraphs 14 to 20 begin at page 1084.
361.
Yeah. I should say that by the standards of the other witness statements in these proceedings, it's admirably short and digestible, so I do recommend looking at it, but in particular, paragraphs 14 to 20 set out the points which are then summarised in the subparagraphs in the judgment here. So the concerns that you persisted with throughout related to capacity, to the big problem of respite, insofar as the NWR scheme provided far greater potential for real noise respite than Hub's scheme. The noise effects, to the novelty and related safety concerns, and to the deliverability. There's a quote from Hull's response to the Airport Commission's initial assessment. The bundle reference for that is Supplementary Bundle 1, tab 19. And you'll see there that that's the quotes there from Hal's response referring to commercial complexity, consenting strategy and the construction schedule. And then finally the question of costs. And then at 36, the Divisional Court records that underlying many, if not all, of these concerns were the fact that the scheme was a novel proposal. And then there's a further quote from Hal's response to the Airports Commission. Just picking it up at the final part of paragraph 36, Mr Humphreys in his submissions below explained that because of these concerns over the greater noise impact of the NR scheme and the lesser respite provided for residents and businesses, combined with lower movement capacity, I'll assess the scheme as being less consentable, i.e. carrying a greater DCO risk, and also as having a greater risk of delay. And then the court's findings on these points are at paragraph 37. So which found that it understood, of course, that when voicing these concerns, Hull was in the process of promoting its own scheme, and that the concerns can't simply be accepted as well-founded. That must have been as obvious to the Commission and the Secretary of State as it is to us. But neither can they simply be completely discounted. Indeed, as matters going to the objective deliverability of the DNR scheme, Hull was clearly entitled and right to raise them, and we have no doubt that both the AC and the Secretary of State would be interested in and concerned by the technical and planning points made by Hull as an experienced airport operator at Heathrow. Then at paragraph 59 of the judgment, where there's a description of the exchanges which took place between Hub and Hull, paragraph 59 refers to the conversation between Mr Clegg, who's the majority shareholder in Hull, and Mr Haddon-Cave, and I simply draw reference to the final part of paragraph 59, so below the indented quote. It's noteworthy that Mr Haddon-Cave didn't refer to a guarantee but to a letter of support for the scheme, and even that was refused. He merely said that Hull would work in good faith with the claimants if the scheme were chosen. Given the reservations that Hull had about the ENR scheme, see the paragraph above, it is difficult to see how Hull could have gone further than this. And then at 60, the following paragraph, there's reference to Mr Clegg's description of the conversation in a contemporaneous email. And you'll see that point number 4 there, Mr Clegg's summary included that Hull had technical concerns that they felt that they needed to do more due diligence to commit to the detail. And again, the court's observation on that at the very end, after the quoted section, was that it was significant that even Mr Clegg of Hub accepted that Hull had legitimate technical concerns with the scheme, and then quotes from the email above. So, Hull may very well think that Hub was wrong about these issues and the points which it raised in the course of the consultation, but it misses what is the important contextual and factual point for present purposes, which was that Hub wasn't proposing to develop the scheme. The risk on all of these issues would lie with Hull, and in that context it was not only perfectly proper, it was perfectly obvious that Hull, as the proposed developer, was entitled to have a view and express a view on the suitability of the concept in planning terms, particularly in relation to matters which represented the risk to consent and the risk of delay to delivery. And that is the context against which one has to assess Hub's central submission that even giving Hull a right to be consulted or a right to refuse a guarantee or assurance was somehow sufficient to give rise to a conflict of interest which involved the Secretary of State breaching primary EU law. Simply as a matter of common sense, it would be odd if that were the result, and my Lord Justice Lindblom made the point yesterday that competition law, as with other areas of the law, has to deal with the real world. There are conflicts of interest which arise in the real world, and in the submissions I'm going to make, the concept of abuse of dominant position and the aspect of objective justification, which is an inherent part of the concept of abuse, does deal with that, which is why I did submit below. But even if you assume all the other elements of the abuse point and the Article 106 point are satisfied, there's a basic answer to all of this, which is that Hull was objectively justified in the position that it did. It was raising legitimate points which it was entitled to raise. What was my second heading? Was as a matter of principle to raise concerns about the way in which the Divisional Court dealt with these points in its judgment. as has already been observed, the basic point is that in paragraph 162 of the judgment, the Divisional Court, in my submission correctly, identified that this was a public law claim, that it had made a clear finding that promoter-specific issues played no material part in the decision on the challenge.
Can you slow down just a little bit?
I will, my Lord. In case it assists, the point I'm making now is the point of paragraph 10 of my skeleton.
I'm sure it is.
So it had identified it was a public law claim, made a clear finding of fact, and that as a result of that, concluded correctly that the challenge based on the alleged breach of EU law in August 2016 could not succeed as a basis for overturning the decision to adopt the ANPS. And that was a complete answer to the point, and it was at that point unnecessary for the court to go any further. Now, what the court might have said, and which you sometimes see, is, well, if we're wrong about this, or we're not sure about it, or it might go further, we ought to set out what we would say about the EU law point if it becomes relevant. Now, that's not actually what the Divisional Court did in this case. The premise for the last 15 pages of the judgment is set out in paragraph 163, that had the claimants framed their case as a competition law challenge to preference decision in late 2016, the point might not arise. And it's not true for the reason I'll come on to in a moment. But the premise then for what follows is based on a hypothetical situation where the claimants have brought a completely different type of claim at some time in the past, and the exercise the court is undertaking appears to be to analyse whether that type of claim, which was never brought, might have been successful on the basis of the arguments that Hub was putting forward. So again, a completely hypothetical exercise. And the premise which is given at 163 that the point might not arise is not in fact correct when one comes to look at how the court dealt with it. So if one jumps ahead to paragraphs 189 to 192 of the judgment, so I've skipped the sections on dominant position and special and exclusive rights, I'll come back to those, but effectively where it ends up, obviously the first instance is 189 to 190, and the conclusion that's actually given there at 189 to 190 is precisely the same conclusion. At paragraph 190, it's impossible to see how any abuse of the dominant position could arise on the part of Hull, or how the measure could in any way have enabled the abuse, based on the conclusions which are set out at paragraph 189, which are precisely the same conclusions, i.e. the request for the assurance and any response to it was immaterial. And so where that leaves the court is then at 192, which is that because it was immaterial, because the request and any response was immaterial to the ultimate decision, there could not even have been a potential anti-competitive consequence liable to result from the request. So the premise which is forward at 163 that we ought to look at this because it might not have arisen is actually not correct. It's exactly the same reason as given 30 odd paragraphs onwards as to why that claim would not itself have succeeded on the facts. The difficulty, of course, is that in between times, between those paragraphs, you have a whole series of findings on pretty complex and highly contested points of EU competition law, and findings which do have wide application. The Heathrow Airport Limited is an undertaking which has been granted special and exclusive rights, and that it has a dominant position in an economic market which the court itself defined as airport services in the southeast of England. To make matters worse, the hypothetical reasoning doesn't actually stop there, because one sees then in paragraphs 194 and following that yet a further hypothetical is put forward, which is said to be out of respect to the arguments, but it is, having gone through this analysis, let's assume the counterfactual that the request for a guarantee was at least material to the preference decision. Then we should go on to consider whether, even if that were to be the case, the Secretary of State's request was capable of enabling Hull to infringe Article 102. And the So the reasoning at this point is not only what would have happened if you had a different type of claim which had been brought, but what would happen, what would the position be if, contrary to our clear and central finding of fact, the request for an absence of a guarantee was material. And then the conclusion on this section comes at paragraphs 200 to 201. And so at 200, the Divisional Court says, well, if we were wrong in our conclusion that the Secretary of State did not regard the guarantee issue as material, our conclusion would be that the decision was materially affected by it, that the request was a state measure, and that it gave Hull the opportunity materially to influence the preference decision. So that's the starting point. But then at 201, but it doesn't follow even from that there's been an abuse of the dominant position. That is because the preference decision and influencing the designation of the ANPS are two different matters. The fact is that even if there had been an influence on the preference decision, that could not have amounted to an abuse of the dominant position, because the preference decision in no way influenced the structure of the market or had the effect of weakening competition. And the reasoning which follows is the reasoning which Northern Fairness O'Donoghue criticises, which is effectively the preference decision is the start of a long process. There's still the development consent process to follow. People like Aurora and others will be able to come in. Effectively, what's said 206 is the decision did not even potentially, that's the ANPS decision, did not even potentially affect competition or market structure. And in see the same point at 207.1, preference decision was just one step by itself. It had no anti-competitive effect. The question of which scheme should be preferred had no competitive effects at all. So one gets through all of those paragraphs to end up with the conclusion, effectively, that the decision which was challenged is one which could have no effect on any competitive market in any event. Now, you read those and you might ordinarily say to yourself, well, that was all pretty pointless or pretty interesting depending on your point of view, but what does it matter because it's all obiter? But these findings, and particularly the findings on 106 and 102, which I'm going to come to, do have wider and serious adverse consequences for my client. You've heard from Mr. Palmer about the wider consequences for the Secretary of State. But the finding that Hull is an undertaking that's been granted special and exclusive rights is a particular problem, because it creates a situation where any litigant who has a commercial dispute with Hull can come along and assert that Hull is not only dominant in an economic market that the court has defined as airport and related services in the south east of England, but that it's a privileged undertaking, which is subject to the special constraints which therefore arise under Article 106. And it's not theoretical, which is why you may have noticed that Banner's clients, Aurora, seek to uphold those aspects of the judgment. You know, Aurora is nominally intervening in support of the Secretary of State. It does basically support the Secretary of State's position in the appeal. But there is, in fact, an ongoing claim between Aurora and Heathrow Airport in the Chancery Division, which concerns the approach that Hillingdon, the planning authority, is taking to a planning application by Aurora for a car park. And it is being directly argued in that claim that if Hillingdon does not interpret the planning condition in a way that benefits Aurora rather than Hull, that it will put the planning authority in breach of Article 106, because Hull has special exclusive rights and will be put in a position where it will inevitably abuse its dominant position. So it's entirely unsurprising, and I certainly don't make any criticism of him for it, that Mr. Banner and his clients would be relying on the reasoning of the Divisional Court in that other claim. So, I mean, instead of simply saying, as to the extent it had to deal with the point at all, what the Divisional Court could have said was, well, we'll assume Article 106 might be engaged, assume that the conditions for an abuse under 102 might even be present. The fact is that the request for a guarantee had no material effect on the preference decision, and even if we're wrong about that, the conclusion that you find at 207, i.e. the preference decision itself, could have no even potential effects on competition in any economic market. And that would have, if that had been the finding, one might still say, well, you didn't need to do that, but you certainly wouldn't have had a respondent's notice from me or I suspect necessarily the Secretary of State. So leaving aside the correctness of the points, which I'm going to come on to, as a matter of principle, my submission is that having made the clear findings that it did earlier in the judgment, the court should not have embarked on the exercise that one sees from paragraph 164 onwards.
So what follows for this court on this appeal? What do you invite us to do?
Well, the difficulty, and I'm about to show you an authority which highlights exactly the difficulty and supports in my submission, the point I'm making, is that we now have 50 odd paragraphs of, strictly speaking, obiter reasoning
Yes.
on quite difficult and quite important points that we use in competition law, which do have consequences beyond this case. And if you, the short answer is that I am inviting you to overturn those findings on the basis of the submissions I'm going to make and in the respondent's notice. They are sufficiently significant and the legal errors contained within them are sufficiently serious that both I and I'm joined in this by the Secretary of State invite the court to depart from that reasoning and indeed find that the divisional court was wrong for the reasons of the case. And of course, merely in the course of dealing with Hub's appeal anyway, you are going to have to grapple with the points that Mr. O'Donoghue raises. His position is he sort of won on 75% of it, and there's only one aspect of it that he needs to raise, but even that aspect, in dealing with that one, essentially has no option but to delve into the swimming pool that is the difficult points of the competition law.
My Lord's question goes effectively to our jurisdiction, doesn't it, in this appeal? The breadth of our jurisdiction.
Yes, I mean, I think formally there's no difficulty because we've put in respondents' notices, so we are inviting the court to uphold the decision, but for different or additional reasons.
Yes, but is it collateral to that you ask us to grapple with the reasoning in paragraphs 164 onwards of the Divisional Court's judgment and effectively overturn the obiter dicta there?
Yes, I mean, the very point of our respondents' notice is that we challenge the findings in those paragraphs.
So it's a direct challenge
It's a direct
to those
challenge to
paragraphs,
the findings. Yes.
not a collateral challenge. So you're attacking those paragraphs head on, inviting us to overrule them.
Yes. The danger, from our point of view, is that what you might be tempted to do, of course, is to say, well, we agree with the central factual finding, and on that basis, we don't have to deal with the other points because we can supposedly appeal on that basis.
Perhaps putting the matter at its most extreme, would it be open to this court simply to observe that those paragraphs were obiter, and on your submissions that this court disagrees with them? Is further reasoning required than that? Given that they're obiter.
If you disagree with them, that slightly begs the question why you disagree with them.
Yes, of course. But then they're obiter.
They're obiter. So, Your Lordship's not the first Lord Justice of Appeal to ask me this question this year, and my Lord may recall that in a case earlier this year, in which my Lord Justice Haddon-Cave sat with the Master of the Rolls, and I think Lord Justice McClune, I appeared for Secretary of State and was putting forward a pretty similar argument. There was an obiter finding of the upper tribunal, which was deemed problematic on a wider basis. It was an immigration case. And perhaps unsurprisingly, the Court of Appeal was rather attracted to the suggestion you just made to me to say it was entirely obiter, it doesn't create any precedent, and we're not saying anything about it one way or the other. So that's a case called Kavanagh. I've got copies if you'd like to see it. But it would be
in a sentence, what approach did the court take in Kavanagh?
Well, it was a pretty minor. It was nothing like the scale of this.
No.
I mean, it was not this kind of reasoning and findings. There was no suggestion it would have wider commercial consequences and so on. Shall I hand it up and you can see there's a short paragraph at the very end.
It was a very different context, if I remember.
It was a very different context, my lord. go simply to the very end of this judgment, so paragraph 86 on page 3675.
This is the judgment of the court.
Judgment of the court.
And paragraph.
So the section starts at 86. But I mean, the critical point really is that the upper tribunal had suggested some basis in which EU nationals might be able to establish relevant links for immigration purposes and being able to access benefits. And at 89 the court said, well, in view of our decision that in the main appeal the appellant succeeds, so there was a genuine and sufficient link, the issue of general principle doesn't arise. It's inappropriate for us to address it. Highly unlikely that it would actually arise in practice, the concern. And then at 90, the observations do not form part of its essential reasoning ratio, do not therefore create any precedent, and nothing you're saying should be taken into account.
So the court really poured a bit of cold water
Cold water on it.
on it fairly delphically, but clearly.
Yes, because the concern was there that you were going to have any number of people come along to the immigration tribunal, proceed tribunal, and raise imaginative arguments based on what was frankly a throwaway comment in judgment of the tribunal. Now that it is a different context.
But you said require rather more than cold water.
Yes, my submission
In this
to you
case.
is that in circumstances where the points in any event arise to some extent on the main appeal, you have a respondent's notice from the Secretary of State who has made a submission that this point has potentially serious wider consequences for the Secretary of State generally, and the respondent's notice from me, and an example I've given you where it actually is creating real problems in other litigation. My submission is that unfortunately, regrettably, the court does need to grapple with the submissions on the substance of what the division of found, and in my submission also will return them for the reasons I want to explain. Just in terms of the principle and the general criticism I'm making of the divisional court, the authority which I added to the bundles this morning, which is at tab 66, is the Flow Telecom case, and it's nothing other than to illustrate the dangers of courts producing unnecessary reasoning on points that don't arise from determination. So this was, it's a slightly different context. This was, in a sense, a winner's appeal by Ofcom from the decision of the Competition Appeal Tribunal. So Ofcom had got the result it liked, but the tribunal's judgment included passages of reasoning which weren't relevant to the outcome, but which Ofcom strongly disagreed with and created wider problems. And the relevant paragraphs are paragraph 20 onwards. So this is the judgment of Justice Mummery in first place. And you see there at 20, he refers to the unnecessary nature of the tribunal's legal rulings with reference to an earlier case of Burke. There are sound reasons why courts and tribunals at all levels generally confine themselves to deciding what's necessary for the adjudication of the actual dispute. That may be described as unimaginative, unadventurous, inactive, conservative, or restrictive, but the lessons of practical experience are that unnecessary opinions inclining the courts are fraught with danger. And then there's a reference to specialist tribunals being especially tempted to try and be helpful in this way, but it does more harm than good. And then there's the point which Mo has essentially raised to me, which is the difficulty that puts the Court of Appeal in paragraph 23. You then face with the dilemma, which is when you have an unnecessarily wide-ranging judgment, and do you accept the appeal against unnecessary rulings and risk making the situation worse, or do you take a purist stance and leave that reasoning there and leaving litigants in a position where they may not have the opportunity to overturn it? And then the points put slightly more pithily, Lord Justice Lawrence Collins, as he then was in the paragraph 122 on the last page, effectively making the point that you can't. Difficult to solve every aspect of the problem satisfactorily and conclusively when only one element is presented for a concrete decision and over to attempt to become advisory opinions. Referring there to a law quarterly article by Justice Haddon of the Australian High Court. So, my submission, my Lord, is that the Divisional Court can legitimately be criticised for the approach that it took to deciding points that were unnecessary for the determination of the claims. But the submissions that I'm coming on to now are to the effect that those rulings were in any event wrong as a matter of law. So my third heading, and the first point on the substance, goes to the question of Article 106 and special or exclusive rights. And if you have my skeleton argument to hand, might be a way to shortcut some of it. So there are two skeleton arguments for Hull. There's our responding skeleton argument on the 30th of August, and then there's a very short supplementary skeleton on the 30th of September. So the points I'm making now start at paragraph 11 of the main skeleton.
Should we put Kavanagh in as 77?
67.
67, sorry.
Yes. As you heard from Mr. Palmer, there was in fact an agreed definition between the parties as to what is meant by the grant of special or exclusive rights under Article 106. And Mr. Palmer did you to the paragraph in the judgment that quotes on the ambulance Werkner case. And in the agreed list of issues for this appeal, the agreed definition which is given is from the subsequent FIFA case. And I'd like to show you that. It does repeat the ambulance Gluckner definition, but it goes further than that by giving some examples. So just for your reference, the agreed list of issues is in the Core 104 tab 10, and it's page 1651. The FIFA case, which I'd like your Lordship to turn off, is in Authority Bundle 2, tab 20.
220.
Have the Advocate General's opinion based on you just have the judgment. And the paragraphs which the parties are agreed are relevant are 176 and 177. And this is, in my submission, helpful because it not only at 176 it essentially repeats the formulation that one found in ambulance Gluckner. So, protection conferred which may substantially affect the ability of other undertakings to exercise the economic activity in question in the same geographical area, and so on. But then at 177 it gives a series of examples. And so the court goes on to say that such rights are an issue when the public authorities have granted a monopoly. And the reference there is the Russell case. You have that at volume 1, tab 13. And as you may have seen from Mr. Palmer's note that he handed up, that was a case concerning the exclusive right of dog workers. So effectively they had an actual monopoly to provide services, I think, in the West Betsy. The next example is when they can prevent the entry of a competitor into the market sphere of the rights holder on grounds relating to potential adverse effects in the operation and profitability of the rights holder's activities. And the example that's given there is ambulance Gluckner, which is of course volume 2, tab 15. So you'll see that the CJU itself, actually I think this might be the General Court, doesn't describe ambulance Gluckner as establishing any principle about unlawful consultation or conflict of interest. The point in ambulance Gluckner, as Mr. Palmer said this morning, is that the operation of the legislation in Germany meant that the public ambulance services could effectively prevent the entry of other private ambulance services in operating in a different non-emergency market. In other words, there was a de facto monopoly. The next example that's given is our labour market requirements, and the reference there is to Beku. That's basically the same. That's a dog workers case again, an actual monopoly for dog workers, in that case in the Port of Ghent. Or where the rights holder is entitled under the relevant legislation to influence the terms under which the activity in question may be pursued by his competitors according to his interests or according to the consequences of their activity on that market or even on the neighbouring market. And the the examples there include France and the Commission, which is essentially the same sort of case as RTT. It's a telecommunications case where there's a right of actual decision. ERT, which you have in Volume 1, Tab 8, which was a monopoly to the Greek state broadcaster. INO, which is in fact a reference to the RTT case, which you can take into Tab 10. So that's the right actually to decide on whether you can connect your equipment to the telecoms network. And then you've got the Greek motorcycle case, and I'm going to come to that in a minute. So all the examples there are, as Mr. Palmer says, examples where you have either granted an actual monopoly or you have granted a decision-making power, which effectively means that there is a de facto monopoly or there's an unavoidable creation of the extension of dominant position in the market to a neighbouring market, or totally excluding competitors. Now, the three cases that my friend Mr. O'Donoghue relies on are RTT, and as you've heard, that was a measure where the telecoms operator had complete discretion, had the ultimate decision-making power as to whether someone else ought to be able to connect their equipment to the network. Ambulance, Gleukner and Merton. Now, can I ask you to look at Ambulance, Gleukner again? It's in the same bundle behind tab 15. And it's just, this is really just to make good the point that my other friend Mr. Palmer made. I think he gave you, broadly speaking, the same paragraph references. So, the first paragraph to look at, well, really the relevant paragraphs are 7 and 8 in particular. And what you'll see there is that in 1989, the law on the conveyance of persons was amended to remove ambulance services from its scope. And so that then fell within the what's referred to as the RECT G, which is the law on public ambulance services. And so the effect of that, you can see the quote from the national legislation is between paragraphs 7 and 8. So the legislation itself provided that the authorisation to operate an ambulance service shall be refused if it would be likely to have an adverse effect on the general interest in the operation of the
Sorry, 7 and 8 of
judgment. So there's on page 8142, there is immediately above paragraph 8, there is a quotation beginning authorisation.
Thank you.
And that's the relevant paragraph from the national legislation. And you'll see that the national legislation made it a mandatory relevant consideration that regard should be had to the reserve capacity of the public ambulance service throughout the territory and the actual use made of the public ambulance service within the operational area. And the effect of that, as my friend said, was that every time someone else came along and said, I'd like to operate an ambulance service, it was always refused, because I think as the court says in 24, Mr. Palmer reminds me I didn't actually describe what's in paragraph 8. You'll see there that, as the court says, that in effect, that the assessment which is mandated by the legislation always results in practice in the rejection of new applications because of the extent of the aid and rescue resources which are kept available by the public ambulance services. So there was always spare capacity in the public ambulance services. The effect was de facto that no one would be able to come along and get a licence to operate a competing ambulance service because the state measure, the legislation, effectively precluded that. So this was not, I endorse and support another from Mr. Palmer's submission on this. This is not a case which demonstrates the proposition that was put forward by my other friend Mr. O'Donoghue that unlawful consultation or merely inviting consultation and giving rise to a conflict of interest can amount to a breach of 106. This is a case where the effect of the legislation was to extend de facto monopoly in one market into the neighbouring non-emergency market. And then the third case that my friend relies on is the Greek motorcycle case, and that is in this bundle at tab 19. And the critical thing to note about the Greek motorcycle case is that the evil, as it were, or the objection was that ELPA, the Greek Motorcycle Agency, or whatever it was called, effectively had a veto, again, because they had the ability to give consent without the possibility of review. And you see that, in particular, looking into paragraph 18, the question which was in fact referred by the Greek court, first of all, was about whether it was an economic undertaking within the treaty articles, and then secondly, does the provision, which in relation to Ministry for Public Order permission to organise a motor vehicle competition, gives the organisation the power to provide a concurring opinion as to holding the competition, without that power being made subject to restrictions, obligations and review, is it compatible with those provisions of the treaty? And then if one jumps ahead to the paragraphs on which Mr. Donoghue relies, and the answer which was given by the Court of Justice, one sees that, for example, paragraph 48, there's reference to the referring court's question, which relates to the ability to give consent without the power being made subject to restrictions, obligations and review, and then that language finds its way into the answers. So at 51, to entrust a legal person such as ELPA, which itself organises and commercially exploits events, the task of giving the competent administration its consent is tantamount de facto to conferring upon it the power to designate the persons and to set the conditions in which those events are organised. And then at 52, again, such a rule which gives a legal person the power to give consent to applications without that power being made subject by that rule to restrictions, obligations and review, could leave the legal person entrusted and so on to distort competition. Again, at the end of 53, the answer that's given refers in particular to the ability to authorise competitions without that power being made subject to restrictions, obligations and review, and then it's there at the very end of the dispositive for the end of judgment as well. So again, this was not a case where the unlawful breach of Article 106 and 102 was simply because they were consulted or they had an opportunity to make representations. It was because they were de facto given the right to consent or not. There was no opportunity to review or challenge that decision.
It's not just confined to that, though, is it? Paragraph 51 appears on its face to contemplate what it calls a situation of unequal conditions of competition. I think that's fundamentally Mr. O'Donoghue's complaint. That's anti-competitive, isn't it?
Well, in the market, in the economic market in which ELPA is operating, i.e. the organisation of motorcycle events in Greece, presumably, it would be anti-competitive if it has the opportunity to decide whether competitors can enter the market and have competitions or not. That's quite true. That's all the court's saying there. I mean, that obviously would be anti-competitive if one operator in an economic market can exclude all the others. It's exactly the same point as one finds in RTT and in ambulance Glockner. Essentially, there is a right to stop others from competing in the market. And in the context where they have made the findings earlier, and indeed the referred question makes the point that this is a right that ELPA has, which is not subject to any review or challenge or decision. It's a unilateral right which they have to say that no one else can organise motorcycle competitions. In my submission, that paragraph is not setting out any broader proposition that simply giving ELPA the right to be consulted or to express views is somehow a breach of Article 106 and 102. So the basic problem, you were just returning to the Divisional Court's reasoning on this. You've seen the case law and the examples given in FIFA. What the Divisional Court decided, as you saw from paragraph 180, was that Heathrow Airport Limited has special and exclusive rights, essentially because the business was at one point publicly owned. And that's essentially the reason.
Because the business
Was at one point publicly owned and then was privatised. So Mr. Palmer took you through paragraph 180 judgment, and I don't intend to do that again. The various aspects of the reasoning which may not be entirely clear, but the principal basis for the conclusion that's 180 little 4 is that Heathrow Airport Limited has somehow accumulated its position in the market as a result of the state granting special or exclusive rights. Now, the basic problem with the analysis in 180 is that it simply doesn't apply the test in ambulance Gluckner and which you then see in FIFA. So there is an established test which all the parties were agreed on, and the question was, has the state granted rights to Heathrow Airport Limited which substantially affect the ability of other undertakings to exercise the same economic activity in question in the same geographical area under substantially equivalent conditions? And the court itself had set out that test in the preceding paragraphs, and then it simply failed to apply them to the relevant question. It's just not addressed. And had that question been addressed, the court would have had to acknowledge that there was simply no evidence before it to support any conclusion that that test was satisfied. As Mr. Palmer submitted, the fact of historic state ownership does not establish the grant of special or exclusive rights. This is entirely without precedent. There is no authority to support the reasoning here. And in relation to those facts, Heathrow Airport was part of a state-owned enterprise, although never a statutory monopoly. And of course, in 1986, when it became publicly listed, it was floated on the stock exchange. So it was sold then to the public and private investors at market value. And when the present owners took it over in 2005, they paid somewhere in the region of £10 billion for the business. And then subsequently, they've been required to divest themselves of airports which they bought, Gatwick and Stansted and Edinburgh. So in no sense were the assets which now belong to Heathrow Airport Limited granted or handed over by the state. They were purchased. The business was purchased on the open market from its then shareholders. So
why were they required to divest of Gatwick and Stansted?
Why did you?
Why were they required to divest?
There was in 2009 a report by the Competition Commission into the need to promote competition in airports, and the conclusion of that was that they would have to divest themselves of either Glasgow and Edinburgh and Gatwick in order to promote competition in the interests of consumers. So that was as you know, the Competition Commission has
and Stansted.
Excuse me, Lord. And Stansted, which they subsequently did, has very wide powers to impose those kind of remedies, and that was the decision. So those were sold and now belong to other airport operations. So what's left is Heathrow Airport, and that of course was bought, as I said, for £10 billion from the shareholders at the time in 2005, who had themselves purchased their shares on the open market post-privatisation in 1986. So there's simply no basis for saying that the assets which are currently owned by the business have somehow been granted by the state or a special and exclusive rights. There is one authority which is referred to in my skeleton argument, paragraphs 13 to 14, which is Secretary of State against ex parte British Telecom, as it then was referred to. I'm not going to ask you to turn it up, but the points really are the points which we make at paragraph 14, which is that there, in that case, the very issue was whether BT and Mercury, the blast from the past, had special or exclusive rights under a particular directive. And the court looked in the paragraphs which I've referred to as paragraph 13 of my skeleton, found that there were no special exclusive rights arising either from the licensing regime or from the fact that licence holders were empowered to acquire land compulsorily. There was a finding that there were special or exclusive rights because BT and Mercury had been given the exclusive right to have international lines, leased lines. But there you had a former state monopoly, BT, which was privatised. It wasn't even argued by anyone that that was somehow relevant to the analysis of whether it was an undertaking that had special or exclusive rights. And the court was obviously court and parties were obviously well aware of the history, in particular because of paragraphs 14 to 17 of the judgment in BT, there was reference to the fact that in 1991 the United Kingdom had moved away from the duopoly position and had started licensing other telecoms operators. So the real question was an economic question relating to the current market and applying the established legal test in ambulance clerkner and FIFA, and the Divisional Court simply did not do that. Now, the remainder of the court's reasoning in paragraphs 182 and 183, I won't, in the interest of time, spend any further time on them. They're responded to in paragraphs 15 to 22 of our skeleton argument, and in our supplementary skeleton argument, paragraphs 4 to 8, and also in the Secretary of State's supplementary skeleton argument, paragraphs 3 to 12. The short point is, I think, as exposed in paragraph 8 of our supplementary skeleton, that the cases which are now relied on simply do not support the reasoning of the Divisional Court, and there is no authority to support the conclusion that the Divisional Court reached based on the historic facts. So my submission is that on this point the court should have concluded that Article 106 was simply not engaged, because Heathrow Airport is not an undertaking which has been granted special or exclusive rights, and so the special constraints that Article 106 imposes on the Secretary of State did not arise here, and that, as Mr. Farmer said, would have been the end of the matter. My Lord, that leaves the question of what the Divisional Court did on Article 102, and there are two aspects to that, my fourth and fifth headings, market definition and abuse and objective justification. The market definition point is addressed in paragraphs 24 to 26 of my main skeleton argument. The short point is the point you've already heard, which is that it is axiomatic in competition law that for Article 102 purposes one must define the relevant market on which an undertaking is alleged to be permanent. It is the critical first step found in every single case. And can I just show you one, we've been taken to a number of EU cases, but in my submission there is a judgment of Mr. Justice Roth in a case called Street Map, which is in bundle 4, tab 47. And actually, for those unfamiliar, I suppose, with the elements of Article 102, Mr. Justice Roth's judgment is a pretty good starting point. Can I just give you one or two references there which I rely on? First of all, in paragraph 40, so I'm in tab 47, paragraph 40. You'll see there, pretty orthodox position, Mr. Justice Roth sets out, for a defendant to infringe the prohibition of abuse of the dominant position, it must hold a dominant position in a relevant market, by its conduct abuse that position, and be unable to show that such conduct is objectively justified. So those are the three elements, and you'll see that he says the burden on the first two is on the claimant, and on the third it rests on the defendant. And then, while we have it open, I also want to draw attention to paragraph 96, where Mr. Justice Roth makes a finding that this is in relation to the question of abuse, that it does not follow that conduct will constitute an abuse where the effect is on a separate market where the undertaking is not dominant, if that effect is not serious or appreciable. On the contrary, it must always be borne in mind that the purpose of competition law is to prevent arrangements or practices which distort competition and to safeguard the interests of consumers. And there's reference there to advocate statements of honour. In jurisprudence under Article 101, it is well established that an agreement or arrangement will not be prohibited unless it may have an appreciable effect. That is logical. There's no requirement of dominance. So the point he's making there, that one has to have regard to what competition law is about, which is practices which prevent distortion of preventing arrangements or practices which distort competition in order to safeguard the interests of consumers. And for that reason, there is essentially a de minimis threshold that has to be passed as a matter of evidence, it has to be demonstrated, in particular where one's talking about effects on a different economic market, that there is an appreciable effect on competition. Now, on market definition in street map, the position is set out paragraphs 41 to 43. And as I've said in my skeleton argument, and as the Secretary of State has said in his skeleton argument, paragraph 19, market definition is a matter that normally requires very detailed economic evidence. That's why we have a specialist tribunal which sits with a judge and two expert economists. It's why Mr. Justice Lindblom in this case has sat with two senior economists in what he refers to as a hot tub, getting to the heart of the economic matters. But just on the question of market definition, 41 to 43, you'll see the position was in this case that at 42, Google denied that it was dominant in the market for online search and disputes the definition and so on. But there was a consent order that the allegations of abuse should be treated as a preliminary issue on the assumption of dominance. This was sensible, because if the abuse allegations fail, that's an end of the matter, whereas if they succeed, the question of dominance can be determined in subsequent trial, will involve extensive disclosure and so on. So that would be a lengthy process looking at dominance in the market. And the approach that was taken here was let's see whether there was any abuse. And the conclusion that he ultimately reached was that there wasn't, and in any event would be objectively justified. And that's a pretty orthodox approach. You also see it, there's a case I'm not going to ask you to turn up now, but it's purple parking. It's in tab 40 of this bundle. And again, that's a case where dominance was assumed and they got straight to the heart of looking at whether there was abuse. And the reason for that is because market definition is not straightforward. And if you have my skeleton argument open at paragraph 24, there's reference to Connect Austria, amongst other cases, and that's a case, and the bundle reference isn't in my skeleton, but it's bundle 2, tab 17. And the references, the paragraphs I referred to in my skeleton are 74 to 77. So that was a case which concerned a state-owned monopoly in Austria, which had exclusive right to operate a particular type of analogue telecoms. And yet, even there, the Court of Justice said, well, we're not prepared to simply accept or assume that this is the relevant market and that they're dominant in that relevant market. And in those paragraphs I've referred to, there's a whole series of factual questions which they say would need to be investigated. Now, you have heard numerous references to distortion of a competitive process, of a competition, of a competitive environment, and the suggestion that there's some kind of procurement exercise or technique here. As Mr. Palmer said, this was not a decision, an economic decision by the Secretary of State to procure anything in particular. There were 52 schemes which were submitted to the Airports Commission, many of them not by airport operators, including so-called Boroughs Island on the Isle of Grain. The fact that you have a competition like that in the context of a planning policy decision does not create an economic market. This was effectively a policy decision-making process. And that is in fact a message of what the Divisional Court ultimately concluded when you get to paragraph 207, where they say, well look, effectively this was a policy decision, it was the beginning of a much longer process, and the decision couldn't have any conceivable effect, even a potential effect, on competition in the marketplace. And the reason for that is because we are not concerned here with an economic market. There are no purchasers, there are no suppliers, there are no consumers. There was effectively a policy decision being taken in which a number of people were putting forward competing proposals. So there was no evidence before the Divisional Court of any relevant economic market. And the approach that the Divisional Court took, which was to look at what the CAA does in a completely different context, was an illegitimate one, not least because the CAA itself says in that decision document, and the references again in the skeleton argument at paragraph 26. So the CAA's determination, just for the bundle reference, is supplementary bundle 1, tab 12. So the references at 26A and B are in that document. The CAA's determination expressly noted that it was engaged in a time-sensitive and context-specific exercise based on the structure of the market at a particular point in time, and it referred to the Coca-Cola case as authority for the proposition that you have to do a new market definition. The Commission has to every time it reaches a new decision. So the findings in the CAA could not simply be read across in the way that the Divisional Court sought to do, not least because of the quite different nature of the test. And I'm conscious of the time, but this is my last point on under this heading, and then my last thing is a very short point. One other reference I wanted to give you is to the CAA's market definition guidance, which is supplementary bundle 2, tab 28. And if you look at that at page 610 in the bundle, they're describing there an aspect of the market definition and market test which they have to carry out under the statutes, which is referred to as Test A. And you'll see in the quote at 4.5 on page 610, what they say in their own guidance document is that there are some parallels between making market power determinations and investigating complaints under competition prohibitions, but there are also important differences. For instance, when assessing market power in an airport as a whole, we usually consider the overall bundle of services, then determine the relevant market. And in assessing complaints under competition prohibitions, we need to start by determining a product market relevant to the complaint in question. And this may be much narrower than the total range of services offered. So the point that's being made there is that in competition law, as opposed to under the statutory regime the CAA operates, you have to ask what is the relevant product market and identify that market and then define it by reference to the nature of the complaint. Here we were dealing with a competition for proposals for a new runway capacity. It's been alleged that that's a product market where the distortion is set to arise, but there is no evidence of any economic market in relation to that matter. And my submission is that there isn't one. There simply is no such economic market as the competition for runway proposals.
Indeed, you would say, presumably, this was a one-off because it was once in a generation competition.
Well, there might well be an economic market for those kind of proposals, which might include architects or airport designers or all kinds of engineers who are able to provide inputs into that market, and then the purchases in that market might well be Heathrow Airport and a bunch of other airport operators. But there's no evidence about that market here. Highly questionable whether Heathrow Airport would have a dominant position in relation to that economic market. And on that basis, for the court to say as it does, I mean, the reasoning, I don't have time to go through it in detail, but the reasoning, paragraphs 167 and 168 in particular about the market, I mean, there's numerous different references, slightly different formulations to a market for airport services, to a market for airport capacity. At one point, the Divisional Court says, well, the CAA is engaged in a different task, so we can't rely on that. And then at a later point, they say the claimant was entitled to rely on the CAA's determination. But the reasoning is, to put it frankly, all over the place, and does not, in any sense, comply with the orthodox approach to market definition that one finds in all of the domestic and EU cases. As Mr. Palmer put it, these kind of detailed econometrics are not a matter of intuition, they're not a matter of judicial instinct. That's why we have an expert competition tribunal with non-lawyers sitting on it, economists sitting on it. It wasn't open to the court to simply reach the view that it did by assertion, essentially, as to the nature of the relevant market.
Mr. Chenna, you've taken your hour.
I have. Well,
how do you propose to conclude by 3 o'clock?
I think probably I have to conclude before 3 o'clock, so I'm slightly over my hour. I have one final point, which is an objective
The court will
justification.
decide when you have to conclude.
I'm grateful, my lord.
You have until 3 o'clock.
I'm grateful, my lord. I'm on my last point, which is a short point, and it is on the question of abuse and objective justification. This is the point which is dealt with in the final paragraphs of my skeleton argument 27 to 32. And can I, as a way of shortcutting it, if you have my skeleton argument at paragraph 28, can I again give you some references to Mr. Justice Roth's judgment in Street Map? So perhaps it might make sense to write these on my skeleton argument, paragraph 28. It's effectively, the propositions are that a finding that conduct constitutes abuse requires consideration of relevant circumstances. That's Street Map at paragraph 61. That in determining that question, the court must take into account as a very relevant consideration evidence as to what the actual effect of the conduct has been. Paragraphs 88 and 90 of the Street Map. And then there's the point at 96 I've already given you, which is that the effect must be serious or appreciable. So, again, there is a need in this kind of case for a claimant to prove convincingly that alleged abusive conduct will or is likely to have an appreciable effect on competition in an identified relevant economic market. And that need to be able to demonstrate some actual economic effect must particularly arise in these circumstances where Hull operates under rigorous ex-ante competition regulation by the CAA. Everything that Hull does in relation to the provision of airport services is regulated on an ex-ante basis by an independent competition regulator. So to simply come to court and assert that a particular measure has put Hull in a position where there is a potential abuse of a dominant position is a non-starter in a normal case, and in a case where one is dealing with a highly regulated market, it's simply not sustainable. And without any evidence, again, my submission, the Divisional Court was simply not in a position to undertake the analysis that the law requires in order to make any finding about potential abuse under Article 102.
The street map paragraphs which 21, 88 to 90 and...
It was 61, my
sorry,
lord.
61.
I'm sorry they're not in the skeleton argument. 88 to 90 and 96.
Thank you.
And then finally there's the question of objective justification. I showed you the paragraph in Street Map, paragraph 40, which establishes that lack of objective justification is a necessary element to demonstrate abuse. If you need it, I think the other paragraph reference is already in my skeleton 31. It's paragraph 142 in particular in Street Map, where Mr. Justice Roth, I think, describes it as well established. And in this case, for the reasons which I explained at the outset of my submissions, Heathrow Airport Limited's position in relation to Hub's request was based on legitimate planning concerns and was objectively justified, as the Divisional Court itself found at paragraph 37. So even assuming that the claimant could somehow make out all of the other necessary elements of Article 106 and 102, the ultimate answer was that Hull's conduct could not sensibly be described as an abuse of a dominant position, because it was legitimate for Hull as the proposed developer and as the airport operator to raise the concerns that it did. There is a pleading point which is taken in relation to this and the dominance argument. I have addressed it in my supplementary skeleton at 14 to 17. The short point is that both objective justification and the need for market definition were raised below, and in any event, whether they were raised or not, the Divisional Court's made findings on them, and I'm entitled, as I have done, to raise the points by way of response.
Thank you.
So I'm not intending to say any more about that.
No, thank you very much. Thank you.
I'm sorry that's been a bit of a rush.
No, but thank you very much. Mr. Banner.
My Lords, I hope I shall not have to submit that Mr. Ficello eating into my considerably shorter time limit is an abuse of dominant position.
What does the agreed timetable say about your time?
Half an hour. I hope I'll be less.
That's what you had.
It didn't work out last time, but I hope I shall do better this
If you
time.
do better, then that will be commendable, but you have half an hour.
Thank you. My Lords, as before, I have a speaking note which hopefully will facilitate expedition. I'll hand that up and circulate it. There is also one case which I'd like to refer to, which isn't before you. I believe by my count that's 68. So, with 3 copies of each. My Lords, a couple of preliminary matters. Firstly, I'm going to follow very close to the structure of my skeleton, so please can you have that to hand if you don't already. Secondly, I'll address the competition law issues only, as per the skeleton. And thirdly, the structure, with one caveat I'll come to in a moment, the structure of my oral submissions will be firstly to do with market dominance and special exclusive rights, very briefly. Secondly, with Hub's Ground 2, and finally with Mr. Ficino's criticisms of the High Court's judgment. Before I embark upon that structure, can I, whilst Mr. Ficino's submissions are fresh in the mind, ask you to turn up the agreed list of issues in the Hub appeal? That's core volume 4, page 2145. Core volume 2145. Something directed by Mr. Justice Holgate of all the parties. 2145 is the title page. 2146 is the page I want to draw to the Court's attention.
Thank you.
Under Ground 1, whether the designation of the MPS is unlawful by reason of breach of Article 106 combined with 102. In answering that question, the Court will need to consider A, whether the guarantee request was a state measure, that's no longer in dispute. B, if so, whether special exclusive rights had been granted. And C, if so, whether the state measure gave risk to arise of an abuse of dominant position by Hal, or a actual abuse of that dominant position. So I'll come back to that in the context of the final part of my oral submissions, but it may help us to have that in mind at the outset. And you can put volume 4 away.
Thank you.
I turn then to the note of the first section. The reason I deal briefly with market dominance and special exclusive rights is because they're principally matters for Mr. O'Donoghue to put forward, because they're essential ingredients of his competition law case. I rely upon the skeleton, paragraphs 23 to 24, which set out my position in relation to that. Just 2 points of elaboration. 23 deals with market dominance, and the final words of that paragraph refer to CAP 1433, the CAA publication. I'd like to ask you to turn that up. That's in Hub Volume 2, page 617, behind tab 28. You there have the definition of market power, in quotation marks, italicised. I draw your attention to the footnote 66, which refers to the United Brands case. I provided you with that case. Due to time constraints, I won't turn it up.
Sorry, page?
Page 617 of the CAA publication. Bundle 617, internal page 35. Footnote 66. And the point is that the definition of market power is framed by reference to the United Brands decision. The United Brands decision is a decision about the definition of dominance. Therefore, the point I'm giving you direct paragraph 65 of the judgment, therefore, a finding of market power entails a finding of dominance. For reasons I'll explain later, it matters not, for my purposes, whether the market in which Hal is dominant is Heathrow standalone or the South East. What's critical is its airport operation and related services, and not Hub's kinds of activities, covering at least Heathrow. That's all I want to say on market power. Point 3 of the note, special exclusive rights, elaborating paragraph 24 of my skeleton. My own friend Mr. Palmer's submissions read paragraph 182.4 of the judgment, and it probably is necessary to take it up at this stage. That's, we need to go back into volume 4. Judgment. Paragraph 182.4c, where the court hands of public undertaking constituted the granting of special exclusive rights first to BA and then to HAL. He attacks that as having fairly profound, broad implications. What I say in the note is that needs to be read in light of the earlier findings of 1821 that HAL is a privilege undertaking for reasons that include the highly regulated nature of operation of airports, and 1821 needs to be read in context with 1832, where the court didn't agree with Mr O'Donoghue that the regulatory powers HAL has, including the ability to make bylaws at Heathrow, didn't agree that was a freestanding basis for finding it was a privilege undertaking, but thought it nonetheless was cumulatively relevant. So, in my submission, when you read 182 4C in context, and fairly, it does not have the broad implications that Mr Palmer suggests that it does. It's probably worth keeping the hub judgment to hand, because I will be dipping out of it if that's not too inconvenient thought. I turn then to paragraph 4 of my note, the second heading, and hubs ground 2. And my lords, the section of the judgment of paragraphs 199 to 205 reflect my submissions to the court below, which were almost identical to those set out in my skeleton in paragraphs 26 to 35. What I propose to do, if it's convenient to the court, is take you through the key steps of my argument, responding as I go to Mr O'Donoghue's rebuttal. And that's why I asked you to have the skeleton before you. Paragraph 5 of the note, as I say at paragraph 26 of my skeleton by reference to the DEI case, an essential ingredient for a Article 106 claim is a potential or actual anti-competitive consequence, and I underline that word, my emphasis, liable to result from the state measure. Here, the paragraph 6 of the note, the anti-competitive consequence claimed by Mr O'Donoghue is a breach of the principle of equality of opportunity of access to the market, thus distorting competition. And for reasons that have already been canvassed by my learned friends, this is the key underlying principle, not only in the Connect Austria case, but also in the RTT and Moto cases, which Mr O'Donoghue relied upon. Paragraph 7, though, that begs the question, what were the potential or actual consequences from the measure complained about in the present case, and in particular, were they liable to distort competition through inequality of opportunity of access to the relevant market? And my lords, with respect, I say it's in this context that Mr O'Donoghue fundamentally mischaracterises both the factual matrix and what the Divisional Court made of that matrix. And there are 6 points set out in paragraph 8 of my note that I have in relation to this. Firstly, his submissions are premised on characterising the process that ultimately led to the AMPS, with the various milestones along the way, as being a commercial competition, his word, with market consequences. And that's an essential pillar for his submission that the request for guarantee was, in his words yesterday, distortion in the structure of competition by putting the fate of one bidder, HUD, in the hands of another HAL, in breach of that equality of opportunity principle. Now, next step in the analysis is, in my submission, the relevant market is the provision of airport operation services, related services, in the south east of England, but the point is just as good if it was Heathrow as our development. Turning into paragraph 28 of my skeleton, this wasn't a competitive tender designed to identify one or more developers or operators, and I adopt Mr Palmer's submissions in this respect. It wasn't a competition for the provision or procurement or prison of such services, or anything like that. It concerned the formulation of land use planning policy to govern future DCO applications by anybody. In particular, I give you reference to Ms Lowe's witness statement. It's a lengthy passage, slightly lengthier than the passage I ask you to read the skeleton. If I may, I'll ask you to read that in your own time.
Yes, we'll do that.
B, I do want to dwell upon. My analysis is also consistent with the way that HUB themselves put the ENR proposal forward. At no stage did they propose that they or anybody else other than HAL would develop or operate the extended northern runway. And if I may, I'll take you to the references at Roman numeral 2. So we need to go into volume 2 of the HUB bundle. tab 32. Sorry, tab 32. And at 673 there is a beginning of an email on behalf of HUB. Dear Secretary of State, bottom of the email at the start of the bottom page. And very bottom of 673, Anthony Clegg is taking the lead on discussions with PAL in order to address the issues you raised. We're working to obtain comfort for you that if our concept was chosen to the government, HAL will be prepared to reach a prompt agreement with us to acquire or license our IP and implement an extended runway. So that was how the ENR concept was put forward to the Secretary of State. If you don't mind, please turn back a few pages to then 670 behind tab 31. The numbering is not very clear, it's been obscured by two sets of pagination. It's the second page behind tab 31. And about halfway down, the paragraph with this ties in.
Yes.
This, and you see there the price that HUB wanted for the IP rights was £100 million. You can put that away for now. I can't promise you won't come back to that file, but I return to revenue with 3 of them. Therefore, on HUB's own case, the choice between the ENR and the NWR did not have any consequence for access to the market in airport operation services, brackets whether Heathrow market or South East market. The ENR scheme envisaged HUB getting a cheque for £100 million and thereafter HAL continuing its monopoly at Heathrow. That's what the choice was, that or the NWR. I ask you to consider that in the context of CAP 1433, the guidance on market power in this context. Could you please go back, sorry to keep going back into the same bundle, HUB 2, tab 28, page 619, just as an illustration. 4.35, market features. The choice between the ENR and the NWR did not, in my submission, engage any of those market features. What I will come on to submit, I'll make the point now so I don't have to come back to this document, is that the opportunity for operators to come forward at DCO stage, such as Aurora, to seek a DCO to build and operate elements of the NWR scheme, does engage at least the final new entry into the market, which is for airport operation related services. I turn then, we can put CAP 1433 away, I turn then to point 4 under my paragraph 8 of the note, which refers to skeleton paragraph 29. Next step of the argument is, for these reasons, the consequence, the purpose of the 106 test, the consequence of the process within which the state measure occurred was not the award of any authorisation to provide airport operation or related services, whether at Heathrow or in the South East, but the adoption of the AMPS in its final term. That is the end point to which the various milestones led. That is the thing that had legal effects. That is the thing that's the subject of judicial review. And therefore, in my submission, in judging the consequences for equality of opportunity of access to the market, the consequence of the state measure are the terms that the AMPS must be considered. That's where it ultimately ended up. My next point is that it was the divisional court's point, more succinctly expressed than me, at paragraph 203 on page 2024. And we do need to go up to the judgment again to deal with at least the next point I made, the sixth point on this, where my learned friend, with respect to him, mischaracterised the court's analysis, and indeed my analysis, as involving the heretical proposition that any distortion of competition was cured by the AMPS. And on the contrary, this point is integral to determining whether there was a distortion of competition in the first place as a consequence of the state measure. And I rely in that regard on the first sentence of 205, the last sentence of 201, and indeed 206. Again, given time.
Mr. Banner, in that paragraph, your subparagraph 6, when you use the phrase state measure, what are you referring to? Do you mean there the ANPS?
No, I mean the request for guarantee because that's the state measure complained about. But the request for the guarantee was a step along a road that led to a destination. And given that one has to look at consequence, therefore I say the ANPS is the prism through which one looks at whether the state measure had the nefarious consequences. That's how I put it. If I may then, I go to paragraph 9 of my note. Sorry, I'm getting a slightly faster pace now, I'm not really worried, but I hope you understand why. And I would go then to paragraphs 30 and 31 of my skeleton.
Yeah.
Which is then, well, let's look at what the terms of the ANPS state. It's applicant neutral. Anyone, in principle, could apply for development consent order. Sorry if this is obvious, or no. A DCO can include compulsory purchase powers. You don't need to be a landowner to seek or obtain one. The ANPS constrains what may be applied for. It does not constrain who may apply for it. No one is shut out from the market. And that's clear from, and I think again, given the time, I'll give you the references, if I may. They're there, paragraphs 115 to 116 and 411. It is explicit. It's not a question of inferring that, it's said so in terms. And it's also said so in terms that it's possible for different people to apply for different parts of the scheme, including terminal infrastructure, through different DCOs. Therefore, the final sentence of paragraph 9, the ANPS expressly provides for equality of opportunity between would-be applicants, developers or operators, and thus equality of opportunity of access to the relevant market, whether that market is airport operation related services at Heathrow alone or such services in the South East. If I turn then to paragraph 10 of my note, paragraph 32 of the skeleton.
Yeah.
This characterisation of the term of the NPS was unsurprisingly, it says what it says, unsurprisingly undisputed before the court below. Miss Lowe, in her first witness statement, at paragraph 296, evidences that applicant neutrality was a conscious choice. And in her second witness statement, I endorse her words, it welcomes applications from any party. So there was evidence on behalf of the Secretary of State making clear it was a conscious choice and they agree with my characterisation. I then turn to paragraph 11 of the note, 33 and 34 of the skeleton, where I make the point that the equality of opportunity expressly provided for by the ANPS is real and not illusory. This wasn't some kind of sham. And I just want to go briefly through the points at 33 in that regard. 33A, genuine and will be considered by the Secretary of State with an open mind. I need to respond to Mr. O'Donoghue's submission yesterday, where he said that there was, in his words, no real prospect that the project would be led by someone other than Heathrow Airport Limited. With my great respect, I say that's a fundamentally deficient submission for the following reasons. Firstly, there's no evidence to support the view that the ANPS means anything other than it says, or was intended to mean anything other than it says. Secondly, my learned friend seeks to suggest the Secretary of State it isn't really and wasn't really serious about a DCO application by a party other than HAL by reference to the ministerial submission, which I'll take to in a moment, which in my respectful submission he fundamentally misreads. Can I ask you to take that submission up? It's volume 3 of the HUN bundles, tab 52. This this ministerial submission, 7th of March 2018, a few months before the ANPS was laid before Parliament. The timing and the authorship of the materials, not authored by the Secretary of State but by civil servants, unlike the next document I'll show you, that came later. And I'll highlight a few features of this document. Firstly, page 980, internal page 5. The one thing that's effectively ruled out by the quote from the Secretary of State, following paragraph 16, is the idea of a third party building a runway and operating a runway independently from HAL. think instinctively those comments are not surprising. My client is not proposing to construct the runway, or construct the terminal, so this passage doesn't apply to the concept of introduction of competition through provision of elements of the scheme. Next point is over the page, 981. Lines made with the second bullet of the second box. These proposals, the Lord's proposals, must be taken forward with how. But that needs to be read in conjunction with the third bullet of the preceding box. The CAA has been clear. I'm going to take you to what the CAA said in a moment. It expects how to engage in good faith with airlines. To give you a hint of what I'll show you, the CAA has recognised it has power to force how to cooperate if it considers it so appropriate. So, yes, cooperation is needed. Clearly, any new terminal operated by an independent has to link in with the rest and integrate with the rest of the airport. But if that cooperation isn't forthcoming commercially, the CAA has power to require it. So those aren't observations against in support of Mr. O'Donoghue's submission. And then finally, I note in passing, page 977, paragraph 7 was the point I deal with at paragraph B of 33, the reference to support from the airline industry.
Yes.
I then turn, if I may, this is now 11.1c of my note. My own friend regrettably ignores the cabinet paper. That's at tab 56 in the same bundle. Cabinet paper, the day that the ANPS was laid before Parliament, authored by the Secretary of State himself, and paragraphs 132, 133, I refer them in my skeleton. 132 reiterates the airline community's enthusiasm for the Aurora proposal and the CAA's engagement with it. 133, I'll come back to highly challenging. Whilst we're highly challenging, they'll ever come forward.
Sorry, you're on page
1042.
104.2, yeah.
1042.
That's in tab 56.
It is, yes. Whilst it would be highly challenging for another to come forward, given land ownership and extent of cooperation needed, I'll come on to that in a moment. The ANPS does not preclude third-party applicants doing so. Any such application will be considered properly and with an open mind. So, clearly the Secretary of State keeping an open mind, no basis for saying otherwise. I don't shirk from the reference to highly challenging. Any DCO is highly challenging, particularly this one. That's why Aurora has an army, a multidisciplinary army of professionals working for it and spending a fortune on those professionals. We're taking it very seriously. The point is, the MPS allows us to pick up that gauntlet. That's the critical point. And as to the reference at the end, the reference to how the only body that can deliver the entire scheme alone, well, that's the runway point. We're not proposing to build the entire scheme, just the terminal and associated infrastructure. This is probably a suitable point to come back on the percentage land ownership. For what it's worth, I suggest nothing as it happens. I can't improve on the about 40% figure I gave.
Yeah.
To be clear, in terms of 40% of what? 40% of the land that we need to do the bit we want to do. Aurora does have interests beyond the area of the bit of the scheme that it wants to deliver. That obviously is well, it's
Right,
a matter of compensation rather
we'll assume it's 40% of
Yes.
the land needed.
in ballpark terms.
Yeah.
And finally, this is my 11.1e, my learned friend's submission, with no real prospect the project will be delivered by somebody other than how. It is asking the court, in essence, to rule on the prospects of success of Aurora's pending DCO application, prejudicing, whichever way the court were to be inclined, that ongoing process. So I do say, with greatest respect, it's a wholly improper submission to make. It shouldn't have been made. It's totally without merit.
Sorry, which submission?
The submission that there's no real prospect that the project will be delivered by someone other than how the Secretary of State isn't serious about that. It's totally without merit and should be discarded. I turn then to 11.2. I mentioned the CAA. This play develops paragraph 33D of my skeleton. Can I ask you please to go to bundle 3, pub bundle 3, tab 58. That is a communication by the CAA from August 2018, and two pages I want to draw to your attention. The first is the first page on 1049. This paper is directed at the possibility of, last line, where a third party makes a successful application for development consent. And page 1053, the second, third and fourth paragraphs are where the CAA does what I foreshadowed a moment ago, recognises that it has power in principle, should it see fit in due course, to require how to cooperate with a third party such as Aurora in the event that they were to obtain a DCO.
This is August 2018.
Correct.
Yep.
Turning to my note, skeleton paragraph 34, the conclusions I invite the court to reach at 34 are therefore justified, namely that the opportunity provided for bodies other than HAL to seek a DCO for substantial elements of the NWR scheme is real and not theoretical alone. And that opportunity bears on at least one of the market factors. That's the point I alerted you to earlier by reference to CAP 1433. One of the market factors, namely new entrants into the market, the relevant market. And that again applies regardless of the market for airport operation and related services is Heathrow or the South East. As long as it's at East Heathrow, the point is a good one. Therefore, paragraph 35 of the skeleton, it follows from this that the consequence, which as per the DEI case is what one's looking at, the consequence of the state measure complained of was not either potentially or actively anti-competitive. The equality of opportunity of access to the relevant market has been preserved. And therefore, an essential ingredient of a 106 claim, namely the consequence referred to in the DEI case, is absent. And therefore, the paragraphs 199 to 205 of the original court's judgment were, in my submission, well-founded. Finally, Mr. Facena's submissions. Firstly, it's not entirely clear to me where ultimately they go now, because despite his criticisms of the original court, ultimately he's asking you to make a finding on whether the bits of the judgment he said they shouldn't have included weren't right. And other parties are inviting to read contrary findings. So in my submission, it may not, whether the divisional court are or aren't to be criticised, may not ultimately affect you.
Do you accept that those passages are obiter dicta?
Can I put it this way? I'm not seeking to up the question, but can I preface this in the following way? They relate to essential ingredients of the claim brought by Mr. O'Donoghue's clients. You saw, go back to the list of issues earlier. To make good a claim under Article 106, one needs to show there was a state measure, that there was a body in a dominant position, they had privilege of their special or exclusive rights, and that there was the potential consequence referred to in the DEI. Now, the court ultimately concluded that those ingredients were lacking for a multitude of reasons. So whether the fact that any one element of those reasons wasn't of itself necessary could be said to be obiter in one sense, but nonetheless they relate to issues that were central to the debate before the court. And I put it this way, Mother, the degree of centrality of those issues will, of course, depend, at least to some extent, on how you define, how you determine the other issues.
No, that's not a question
Yes.
of what we decide. It's a question of what the divisional court has decided. The question that I put to you, which I'll repeat if I may, is whether the passages to which you are referring, which were the subject of Mr. Facena's submissions, standing as they do within the divisional court's judgment, are or are not obiter dicta.
With the preface I've given, I accept they are obiter, but that is not to be taken as a criticism of them for including those, because they were points that were central to the dispute, which may inform an appeal either before this court or potentially this is a case which plainly has potential to go further. and depending on which, if it were to go further, it may become even more central before the Supreme Court. So they're playing the issues, going as they did to essential ingredients of the claim. It was appropriate to make them. I draw three, if I may, just conclude by the, as follows. Outline at least four different scenarios. Firstly, imagine a judicial review on 3 grounds, and the judicial review succeeds on 1 ground.
What are you referring to now?
To try and put this issue into context.
Well, this is not in your notes.
I've reached the end of my note. I'm responding to Mr. Ficina's oral submissions.
Right. Well, you're at the end of your time now, so we'll allow you to make this submission.
Thank you. So, scenario 1: judicial review, argument 3 grounds succeeds on 1. It's not inherently inappropriate for the court to make at least brief observations on other grounds. Scenario 2: judicial review ground found without merit for a multitude of reasons. Not inherently inappropriate to not to stop at reason 1, but to explain why there are a multitude of reasons why the judicial review ground is without merit. Scenario 3: the telecoms case. That was where the court went on to consider completely extraneous matters. It went on what I've described in paragraph 15 most of the frolic into irrelevant territory. It's not the easiest case to digest, to say the least, but in addition, what one gets from the head note at D to G and page 1118B to C is that the telecoms flow sought to, they had a license from Vodafone to use mobile phone airspace in a particular way. Vodafone suspended that license, saying that the way that Flow wanted to use their license was outside Vodafone's own license, so in fact they couldn't sublet, it was outside their power to sublet. Flow complained that was an abuse of dominant position. It went backwards and forwards. Ultimately, the OFT said it wasn't an abuse of dominant position, but they went on to say, nonetheless, it would be unlawful for Vodafone to have an absolute prohibition on Flow doing what they did, because it would be within the terms of their licence, and sort of put down a marker that Vodafone shouldn't act that way. That's very different to saying that all the essential ingredients of the claim are not made out in this case. So it's not on point. I haven't had a chance to look at the case that my Lord Justice Haddon-Cave determined, but his throwaway remark was how the point was described. This is not a throwaway remark, it's about essential ingredients. The very last point on this thing, my learned friend Mr. Ficina said that the observations on market and special exclusive rights had implications for the chancery proceedings. Those proceedings concern car park services. Car park services are not within the market as defined by the CAA in Cap 1433. In the market power determination. They're excluded from the relevant market. The bundle reference to that case is Hub 112, 158 to 159. This is the thing. So therefore, there is not that direct consequence Mr. Ficina contends for. Unless you have any further submissions, sorry to go 5 minutes over, going for a slightly faster pace. Thank you.
Thank you very much, Mr. Werner. Thank you. We're going to take a short break. Before we do that, Mr. O'Donoghue, Mr. Kingston, an hour and a half, is it?
Yes.
And you'll need all of that, will you, to reply?
Probably, but we shall try and do better. You may be sure we shall not.
Well, we will allow you an hour and a half if you do indeed need it.
Just in order to assist with that, indicate that we've provided 2 additional volumes. They respond to questions which were asked yesterday.
Right.
One is the appellant's bundle of further authorities for relevant or material considerations, and the other is the appellant's bundle of further authorities for legitimate expectation. They both have a note in them which responds to the questions that my lords asked yesterday,
Right.
and at least attempts to deal with the authorities that we received, I have to say, fairly late last night, which is why we've not got them tabbed so that they can go into the bundle in due course with the cooperation of the other parties. We'll try and produce a composite index which will ensure that there's no duplication.
and they are all then suitably numbered. What it says.
Right, thank you. We'll come back at 22.4.
All right.